Law School. We just learned an interesting little tidbit. We were talking about your wife, and we've talked about her before, who was in the helicopter when Nixon left in '73. You said that he ceased being president while over Jefferson City on Air Force One.
Yes. President Nixon, August 9th, 1974, gave his final remarks in that emotional appearance, McGraw in the East Room, got on Air Force One, and he was still president. In the intervening hour then, they reassembled everyone, and President Ford took the oath of office. When President Ford said, "So help me God," and the Chief Justice said, "Congratulations, Mr. President," Air Force One and President Nixon were just southwest of Jefferson City. At that moment, he ceased to be president, and Air Force One pilot Colonel Albert Hazy called the Kansas City Center and said, "We are no longer Air Force One." And Annie was on the aircraft.
That is a great story. There's a little tidbit of information you didn't know. All right, Greg Willard, our law school is in, class is in session. Put your phones down and pay attention because he is the best. So last week, the Supreme Court ruled in a 7-2 decision, which is about as unanimous as you can get here in 2017.
With this court, you're right, McGraw.
That Missouri and the Blaine Amendment, did they rule it unconstitutional? What did they rule in this very simple story of this religious school wanted a safe playground? What happened?
Let's see if we can go back to our grade school civics class for just a second and set the stage.
Okay.
First Amendment to the United States Constitution says that Congress shall make no law respecting, 1, establishment of religion,
Okay.
or 2, prohibiting the free exercise thereof. That was sort of the set of bookends, if you will, for this case.
Okay.
Missouri had a program during the Nixon administration that allowed schools to apply to receive recycled tires to put on their playground, and then they'd be subsidized. The Trinity Lutheran Church School in Columbia, Missouri made an application. They were one of the most qualified among the group, and they were turned down in their application for these recycled tires for the playground for the kids, because the Missouri Constitution provides that no state funds can go to support a religion. The church sued, and the case went to the Supreme Court. Again, the bookends in the court, McGraw, were the state of Missouri was arguing this is a proper restriction because we don't want to give funds to a church because that violates this clause.
Right, picking and choosing one church over another.
Establishment of religion.
Right.
And the church and its supporters were saying, no, 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 no. We are entitled to the free exercise of our religion, and simply because of our religious beliefs, you are denying us this benefit. Therefore, that's unconstitutional.
Right.
So you had both sides arguing express language from the Constitution. What the court held, as you point out, 7-2, was that the Missouri restriction was unconstitutional. And what a majority of the justices said was that this is a generic program. Any school in the state of Missouri, whether you're a religiously affiliated school or a public school, can apply for this program. To single out a church school solely because it is a church school, 7 of the justices found to be unconstitutional. 2 of the justices—
Who were the 2?
Sotomayor and Ginsburg, in a very, very bitter dissent, said basically the court got the balance upside down, that this is a program that would provide a direct benefit to a church, and that's unconstitutional. If you want to, I think what I found to be a helpful framework, McGraw, is this one. Is this program the same as the treasurer of Missouri writing a check to the Trinity Lutheran Church in Columbia? Or is it the same as the Columbia, Missouri Fire Department and Police Department? If there is a fire at a church in Columbia and the fire department goes out there to put it out, has that that's expenditure of
Right.
state funds.
Mm-hmm.
And so where is that balance? And what the court held by a 7-2 majority is it's closer to the fire and police
Right.
paradigm as opposed to writing a check directly to the church.
Right. Yeah. So it works when it's a good Christian school. If it were a Muslim school, right? If it were a school, what constitutes a religious school? And so if a Muslim school applies for the same grant next year and gets the best score of all the schools, then Missouri can then donate the money for the recycled tires to the Muslim playground.
Oh, I think they most certainly have to. Now, the Greitens administration has changed the policy to eliminate this religious exclusion, but one of the technical points of this lawsuit was a lot of parties had advocated the court should not hear it because of what the Greitens administration has done and said it's moot. The case is moot.
Right.
And Chief Justice Roberts, writing for the majority, said, well, it's not moot because Missouri could change this rule again tomorrow.
Right.
So
A new governor could come in.
Exactly.
Right.
Or if for whatever reason, God help us, the state of Missouri began to pick and choose among religions as to who to exclude and not exclude. But I think that goes to the heart of the court's decision, McGraw. If you're going to have a program that's generic,
right,
and you suddenly make sublimit restrictions based upon religious beliefs,
right, that
seems to me to get pretty close to the sizzle line in terms of that second prohibiting free exercise that we just talked about.
So if you're happy that this Christian school got this grant and that this playground can happen, you have to be happy that a Muslim school with the same criteria gets it, or a religion you don't necessarily agree with or have issues with, right? I mean, that's the question. The other side is, I guess the two were saying, you're opening up a door. Where does it end? And I'll ask you this question. What happens when a state like Missouri says, we're going to give you $5,000 and you can send your kid to any school you want, including a religious school, because it's your choice? Is this now affected by this ruling?
Two questions there. Let me see if I can take them one at a time.
Professor Willard in the back. Go ahead.
In the question of picking and choosing between and among religions, that goes to the heart of what the framers in the late 1700s were seeking to avoid.
Right.
The United States government under the First Amendment and the 50 states now under the 14th Amendment cannot make laws that prohibit the free exercise of religion. So this notion of picking and choosing, it is so inimical to the Constitution. In terms of the subsidies, here's $5,000 for private schools.
Private schools, right.
I guess looking at the totality of the opinion, I think that strengthens the prospects that the Supreme Court would hold those vouchers constitutional. In this opinion, Chief Justice Roberts, and he was joined by Kagan, Alito, and Kennedy, they joined in a footnote. I mean, this is how nuanced this opinion got, McGraw, but it's come to be known as the infamous footnote 3 already.
Okay.
And what the four of them said is, this case applies only to recycled tires on the playground.
Not this
Back
again.
to Bush v. Gore.
Oh, not this again.
So, and the other three that made up the seven did not sign on to that. But putting that reservation that the Chief Justice...
Who were the three who gave the footnote?
It was four. It was Roberts, the Chief Justice, Kagan,
Kennedy.
Alito, and Kennedy.
Oh, Alito.
Mm-hmm. And Kennedy.
And Roberts. Wow, two very well-known conservatives.
Right, and that's why it was such an unusual mix with 7-2.
Right.
But I think in terms of the opinion, I think we can take two pieces from it and apply it to your question in terms of school vouchers. The first piece is, if the school vouchers are a generic program, that would fit squarely in what this Missouri recycled tire program was. Because Missouri wasn't saying, well, we're going to give recycled tires to this subset or that subset. It was any school in the state of Missouri could apply.
Right.
Same thing with vouchers. But secondly is, if a state then, with a generic program, begins to carve out who can participate on the basis of religion, I think you're getting pretty close to violating that free exercise prohibition, McGraw.
So if Missouri passes a law that allows vouchers to go to religious schools, you think that's constitutional in this sense? Or because of this?
Let me change your question a little bit. If Missouri passes a law to provide vouchers, period,
right,
then I think it would fit closer into this.
So you get the voucher, you can put it, you can send it to any school you want.
Yes, but if it says we have a voucher that can be used for religious schools,
right,
then I think they've gone over to that.
Right.
The other, you've established, you violated the establishment
So
clause.
in essence, does this ruling not open the door, and are there not these school choice people, these school voucher people, doing a dance in the aisle because of this 7-2 ruling?
I think the people who support school vouchers, I think they can take encouragement from the totality of this 7-2 ruling by the court.
Interesting. All right, a couple more minutes here, and we'll let you go. Is Kennedy going to retire? What are we hearing?
Well, there was a lot of rumors by the end of the term, but he had a reunion with his clerks, and apparently at the end he said, "Well, I have one more announcement to make." And with great dramatic pause, of course, they thought the announcement was coming about retirement. He says, "The bar is open." So he did not retire. Who knows? That's very difficult to predict. But he's had a long and distinguished career. He's now in his early 80s. So we'll just have to wait and see on that one.
I read somewhere where Steve Bannon, Trump's guy, is sort of tasked with lobbying for him to resign. That's seamless. That's unseemly, right?
I don't want to get into the world of this debate over fake news.
Right.
But I think that's out in that genre.
That's out in left field. I mean, these guys. I mean, these guys are treated with the reverence and the respect they deserve.
Right. They are the 9 justices at the core of our judicial system, and they do a magnificent job. I guess speaking as a citizen, McGraw, I think the 9 of them and substantially all of their predecessors, a terrific job on upholding the sanctity of that institution.
All right, go to the bursar's office. That's worth 1 credit hour towards your degree at St. Louis University Law School. Greg Willard, professor at SLU Law School and the KTRS Legal Analyst. Thanks as always.
Great to be with you, my friend.
9:23.